In the previous section, we examined the affidavit of property value and learned how the buyer, seller, and escrow officer share responsibility for ensuring accurate documentation at the time of recordation. That process marks the legal transfer of ownership and often coincides with the transfer of possession. However, not all transactions proceed with possession, transferring immediately at closing. In some cases, possession occurs before or after recordation, known as pre-possession and post-possession. And these arrangements can create substantial legal, financial, and liability risks for both the purchaser and the seller if not properly documented and managed. Pre-possession occurs when the buyer takes occupancy of the property before the official closing and recordation of the deed. This can happen when the buyer needs to move in early due to timing issues, such as an expiring lease or a job relocation, and the seller agrees to allow access prior to the close of escrow. Although this may seem like a cooperative gesture, it creates significant risk because the buyer does not yet legally own the property. If the transaction fails to close, disputes can arise regarding damages, rent, or repairs made during the occupancy period. Under Commissioner's Rule R4-28-1101J, licensees are prohibited from allowing occupancy by a buyer before closing without the express written permission of the owner or lessor. This rule exists to protect the seller's property rights and to prevent confusion about possession and ownership prior to recordation. Without written authorization, both the licensee and the broker could face disciplinary action from the Arizona Department of Real Estate. A written pre-possession agreement must clearly outline the terms, including the duration of occupancy, rent or fees, insurance coverage, utilities, and the condition of the property upon move-in. For example, a buyer agrees to purchase a home in Gilbert and needs to move in 2 weeks before closing due to a job transfer. The seller agrees, and both parties sign a written pre-possession agreement, specifying that the buyer will pay $100 per day in rent, maintain insurance, and assume responsibility for any damages during occupancy. If the buyer's loan later fails to fund, the agreement protects the seller by allowing them to terminate possession, retain the rent, and pursue damages for any loss. Without this agreement, the seller could face legal complications trying to remove the buyer or recover costs, and the buyer could lose personal property or deposits. Conversely, post-possession occurs when the seller remains in the property after the close of escrow and recordation. This situation often arises when the seller needs additional time to relocate or close on another home. Although ownership has legally transferred to the buyer, possession remains temporarily with the seller. This creates a reversed set of risks. The buyer now owns the property, but does not have physical control of it. If the seller causes damage, fails to vacate, or refuses to leave, the buyer may be forced to pursue eviction through court proceedings. As with pre-possession, a written post-possession agreement is essential. The agreement should specify the exact duration of the seller's occupancy, rent or use fees, required deposits, maintenance obligations, and insurance responsibilities. The seller should also indemnify the buyer for any damage or loss occurring during the post-possession period. A common best practice is for escrow to hold a portion of the seller's proceeds, often $1,000 to $5,000, as a security deposit to ensure timely vacating and property condition compliance. If the seller fails to move out as agreed, the buyer may claim those funds to cover rent, legal costs, or damages. Arizona case law reinforces the importance of clear possession terms. In Rhodes v. Harvey Publications, Inc., Arizona's Appius 1970, the court emphasized that possession and ownership are separate rights and must be treated distinctly in legal agreements. Ownership alone does not guarantee immediate possession unless it is explicitly granted. Therefore, both pre- and post-possession arrangements must be memorialized in writing to establish enforceable rights and avoid future disputes. Real estate licensees play a crucial role in managing these scenarios. Under Commissioner's Rule R428-11001K, licensees must recommend that parties obtain independent legal counsel when entering into pre- or post-possession agreements, given the potential complexity and liability. Licensees must also ensure that these agreements are separate from the purchase contract to avoid confusion or unintended obligations. For instance, if a buyer damages the property during pre-possession and the sale later cancels, the seller's homeowner's insurance may not cover the loss because the buyer was in unauthorized occupancy. Similarly, if a seller remains after closing without a formal agreement, the buyer's insurance may not protect against damage or injury occurring during that time. A real-world example highlights these risks. A seller in Scottsdale closed escrow on June 1st but remained in the home until June 15th without a written post-possession agreement. During that time, a water pipe burst, flooding the property. The buyer's insurance denied coverage, stating the seller was still in possession. The seller's policy had also lapsed. Without a written agreement allocating liability, both parties faced expensive litigation. If a properly drafted post-possession agreement had been executed, it could have specified who was responsible for maintenance, insurance, and damages, avoiding months of costly dispute. Discussion: why must pre-possession or post-possession arrangements always be in writing? Answer: because written agreements clearly define each party's rights, responsibilities, and liabilities, reducing confusion and preventing disputes if damage, delay, or default occurs. What risks do buyers face in pre-possession situations? Answer: buyers risk financial loss if the sale fails to close, potential eviction, liability for property damage, and loss of personal property, as they do not yet legally own the home. Why should real estate licensees advise clients to seek legal counsel before entering into possession agreements? Answer: because pre- and post-possession arrangements create significant legal and insurance liabilities, and professional legal advice ensures proper documentation and protection for both parties. Review summary: pre-possession and post-possession scenarios in Arizona, real estate transactions can be convenient, but are fraught with risk if not handled correctly. In pre-possession, the buyer occupies the property before closing, risking loss if the sale does not finalize or if damage occurs. In post-possession, the seller stays after closing, potentially delaying the buyer's access and creating liability for damages or injury. Both scenarios require written agreements specifying the terms of occupancy, rent, insurance, maintenance, and remedies for default. Arizona's commissioner's rules, particularly R428-1101J and K, mandate that licensees obtain the owner's written permission before occupancy and advise parties to seek legal counsel. Case law confirms that ownership and possession are separate rights, making clear documentation essential. By ensuring compliance, licensees protect their clients, maintain ethical standards, and uphold Arizona's principles of fairness and good faith in every transaction.